Hello, everyone. My name is Anne Skelton. I'm a professor at the University of Pretoria, and I'm also a member of the UN Committee on the Rights of the Child. I'm going to just be sharing with you some information about privacy and identity of children that are caught up in court proceedings. So it's important as a background factor to understand the whole idea about why usually what happens in a court is a public thing. People are allowed to know what happens in courts. The media are usually, as a general rule, allowed to sit in proceedings and to report on what goes on in the courtroom. The reason why we have that rule is that hundreds of years ago, court cases used to be held in private behind closed doors, and nobody really knew what was happening in there. And over the years, it became apparent that that sometimes meant that some pretty bad things were going on, some unfair processes and proceedings which affected the people involved in the cases, particularly in criminal cases. And so gradually the idea developed that it was actually safer and better to allow courts to operate in public. It provided a safeguard, if you like, for the people who were parties in these court cases. And that is why, as a general rule, we find today that the media go to court, they sit in on the court cases, they report. And of course, it is important for the public to know how the law is developing, what is happening, aside from the fact that people like to know the stories about what's happening in society. It's part of the news that we get to hear. However, there has also for very many years been an understanding that there are certain groups of people that need to have some special protection when it comes to court proceedings. And so we've seen, for example, in sexual offenses like rape, case like that, we don't reveal the names of the victims because their privacy is paramount. They need to be able to heal privately. And so we have for a long time said that we must protect them. Child victims of any sort of crimes is another category of children who need protection. And then there are cases that have got nothing to do with the criminal justice system, but what we lawyers call the civil justice system. So that is cases where there are two individuals who are disagreeing about something, and that disagreement ends up in court, and a court has to decide how that should be resolved. Or sometimes it might be the state that is supposed to do something, the government's supposed to do something, but they're not doing it. And so that person will then take a case to court to try to get the government to do what they're supposed to do. So those are civil cases. And what we are talking about today is the extent to which children's privacy and identity should be protected in these kinds of civil cases. It's also important to understand that we have children's courts, which are at every magistrate's court, and those are at a lower level, so it's easier to get to those courts in a way because there's one in every town. And then there are also the high courts, and the high courts tend to be in the bigger cities like Johannesburg or Pretoria or Durban, Pietermaritzburg, Cape Town. So every province has high courts, but they are more difficult to get to, and they generally, it's more expensive if you try to bring a case in those courts. Nevertheless, some children's civil cases do end up in these high courts, and so do cases that, and some cases end up rather in the children's court. So there's two different levels of court. Now, the Children's Act, as it stands currently, before the changes that are being made to the law, says that in children's courts, the identity of the children who are involved in children's courts are protected. In other words, no media person can actually sit in on those proceedings, but also they cannot publish in the media, on the radio, television, or print media, anything that tells the name or would otherwise reveal the identity. So, you might not say Joe Smith, but if you say a 17-year-old pupil who attends this school and lives in this street, you're eventually going to be revealing the identity. So even that kind of information is not allowed to be published. That's what the current law says. But there is a gap in the current law because some cases, as I've explained, don't go to the children's court. Some cases end up in the High Court. And quite often, these tend to be the more high-profile cases. Let me tell you about a case that I was involved with a few years ago, where I was appointed as a lawyer for two children who, when they were newborn babies, had been accidentally swapped by the hospital. So in other words, two mums gave birth at the same hospital, and the staff at the hospital accidentally mixed up the babies and gave the wrong baby to the wrong mum. Those mums went home and they raised those children, and they didn't know that there was a problem until when the children were about 5 years old. The one couple was splitting up, and the father said he didn't want to pay maintenance for the child. So because he said he didn't think it was his child. So the mother said, right, well, I know it's your child, so we'll go and we'll have DNA tests to prove this. And they went and they had the DNA tests. And when the test came back, it showed that he wasn't the father, but also that she wasn't the mother. Well, you can imagine what absolute trauma that causes in the family. So that family was affected, but so was the other family where their actual biological child was living. And actually, it could affect more people because, several babies, actually 11 babies had been born at the hospital on that day. So it was necessary to try to understand and find out what had happened. And the hospital had to do a special sort of inquiry to determine who the other child was. Now, this case ended up in the High Court because the parents were disagreeing about what should happen. One mother, the first mother who first found out that this was the truth, she initially said that she wanted her biological child to come back to her and the child that she had raised to go back to his biological parents. But the other couple completely disagreed. They were very, very bonded with the child that they had raised, and under no circumstances did they want that child to be taken away from them. As time went on, the first mother also began to realize that she didn't want to send her child that she had raised away either. So in the end, what happened in the case was that both of the parents were allowed to keep the child that they had raised, but also both were then permitted to get to know the other child. Now, all of this was big news in the newspapers, quite rightly so, because obviously the story must be told, because we need to realize that there are risks when you go to a public hospital that, well, actually, maybe even a private hospital, any hospital, and that if you are not alert, you might find that a mistake could be made and a baby might end up in the wrong household. So this is something that I would say the public wants to know about. Fair enough. There is no bar on that story being told. The point is, do you need to reveal the identity of the children in order to tell that story? So maybe when you're having your discussion later, you can think about, this. How do newspapers or media stories get told that don't reveal identity, but the story is still told? Because there are many creative ways that one can do that, and I'm sure you would be able to come up with a number of suggestions about how that can be done. So what we want the law to say is simply that the identity must be protected. There is a separate section that says that the public can't sit in on these children's court proceedings anyway. So we're not really focusing on that. We're focusing more on what gets published in the media, what gets known to the public out there. So what we are saying is the way the law stands now, it protects children's and children's court. But what about cases like this baby swap case? And it's not the only one. Other examples are when a child belongs to a mum and a dad who are divorced, and then one of the parents goes overseas and takes the child with them. There has to be a court case about what must now happen, whether that child should be brought back and so on. And these cases always happen in the High Court because the law requires that the High Court decides things where a child, especially because the child will be going overseas or has gone overseas. So again, we would want to protect the identity of the child in that situation. Now, it's also important to understand that there the rule shouldn't be so absolute that you can never depart from it. So I know it might sound like I'm contradicting myself, but what we're really saying is there should be a default position, a rule that says you may not publish it, but the court can give permission if the court is convinced that there won't be harm or prejudice to the child if so much information as is necessary is revealed. So let me give you an example. Let's say a child is kidnapped, and in order to try to find a child, and let's say the case is already in the High Court and there's a matter that's going on, maybe it's a divorce and parents are fighting, and then the one parent just disappears to another part of the country with the child. And then the other parent wants to make the identity of the child known because this is the safest way and quickest way of getting the child back into their care. Now, that would then require, if we had a rule that said that identity is protected, would require the magistrate to say, well, in this case, I'm going to allow it because obviously for the safety and protection of the child, it is necessary. So I just want you to understand that what we're proposing is not so rigid that it could never change. And another thing is that when people turn 18, they might decide that they want to tell their story about what happened to them in their childhood. Let me give you an example there of Zephany Nurse. Some of you might have heard of Zephany Nurse. She was kidnapped when she was a baby. She was only a few days old. Her mum was lying in a hospital, dozing off to sleep, and then somebody said, oh, I'm just going to take your baby for a bath, took the baby and stole the baby and never brought her back. And that family looked for years and years, hoped every year. The media used to try to help them. So the name Zephany Nurse, which was the baby's name, was well known. And things went on like this until when that baby girl had grown up and was now 17 years old, almost 18, she was found again. She was found because her younger biological sister from the family, the mum that had had the baby stolen, she went on and had another child, and that child then started at the same high school. And would you believe it? They had been living only 7 kilometers away from one another. So anyway, now they find out, okay, there's a real, there's a person who is not called Zephany Nurse because she'd grown up with another name. And the media said, we're going to reveal her identity when she turns 18. And she said, look, I don't want my identity revealed when I turn 18 because I've only just found out about this. And my life has turned upside down and I've got to try to learn how to cope with all of this. So I might one day want to tell my story, but at the moment I don't. So therefore, we had to go to court to ask the court to protect her identity. But later on, she decided that she would write a book about it. And that was okay because she had turned 18. And if you are 18 and you decide that you want to reveal something that happened, then it would be okay. And I guess even if you were younger than 18 and you wanted to, then you would have to simply ask the court, may I tell my story? Because I feel that it will help other children if I tell my story. The court might well be considering that would be a good reason and would allow that to happen. So what are we asking for in the amendment bill? Well, we're pointing out that there is a problem, that at the moment there is protection, but it's only for the children's court. So we want a position that will protect children in any kind of court proceeding, whether it's in the High Court or the Magistrates Court, in these civil cases, anything that involves children, we want the identities of the children to be protected. That should be the default position, that only the court can authorize the identity to be known. But at the same time, if that person turns 18 and they want to reveal their identity, there's no problem with that. The law allows for that. And then one other exception is that if the child's identity needs to be told by a social worker, published in the newspaper because they're trying to find someone, let's say a baby is abandoned and the social worker is trying to find the real mother of the abandoned child, then they might put a picture of the baby in the newspaper to say, well, this baby was found on the church steps, and if anybody knows whose baby it is, please come forward. That would be allowed under the law as we are proposing it. We say you should have an exception for that, so you don't have to go to court. And also, when a child is going to be adopted, there is a process through which sometimes they have to put notices in the paper and say, well, this child is being given up for adoption. If the father of the child has any objection, he hasn't been in touch with the child for many, many years, but if he has any objection, this is his opportunity to come forward and say so. So in those circumstances, you would have to reveal the name of the child, not the picture, but just the name, so that if the father reads the newspaper, then he will say, my child is up for adoption. I either agree or I don't agree. So those two exceptions should be written into the law. That is what we're proposing, so that it is clear that in those cases you don't have to go to court if you want the anonymity, the protection of identity to be lifted. Any other situation, you would have to go to court to ask the court to lift that protection, because otherwise all identity of all children in all court proceedings will be protected. So I hope you enjoy discussing this topic. I think it's very timely. We can see that every day in the media, there are stories about children, and it's good. We want to see stories in the media about children. And of course, this wouldn't stop children from participating in programs about things that they are doing, and participating in discussions about things. And even if somebody wants to tell a story that isn't a court case, they could do that by simply making up an imaginary name, a name that isn't their name, and calling themselves that. So I think you can see that there is still a lot of flexibility to get the stories out there. There is still the possibility of telling your own story if you want to, with your identity once you're 18, or with a different identity if you're younger than 18, unless you feel it's so important that you actually want to go to court and ask the magistrate or judge to lift the protection so that you can tell your story. Even that is possible under the law as we are proposing it. All the best with your discussions. Sorry I can't be with you. Bye.